Okay, this is your final review video for the course so that you can begin working on your final exam and any extra credit work that you still want to try to get done before the end here. This last week you've been engaging in a discussion about a two-step process. One is to first find legal rules, which hopefully wasn't too hard for you at this point. And so I pulled some of the answers that you gave on the discussion board from each of the classes listed here, cases listed here. The main thing after that I wanted you to do, this is step one. So step two is then to think about, so what does this have to do with the right to privacy? That's something a lot of people talk about, right? But in a constitutional law class for legal reasoning, you actually have to go back through these rules and you have to see, okay, what evidence do I have that the court is supporting or is against the right to privacy? That's the same thing that goes with the limits of governmental intervention. So in other words, what words, what phrases can I draw from these rules here that help me argue for or against the right to privacy and the limits of government intervention? You'll see there's not going to be one answer. There'll be multiple answers that come across from that, and that goes back to the polyvocality of legality. Then what I want you to do is then think about, as you've gone through this course, many of you wanted kind of what we call rights talk, the idea that I just talk about my rights and they automatically apply, the courts will just rule in favor of me. Now rethink that as you've kind of learned what the courts actually do and how people have used court rulings for and against social change. You want to think about then what does this mean for social groups and their use of rights talk. Now, to highlight the complexity of this course, I want you to imagine you're the judge, and this is a example I got from Justice Scalia from the Supreme Court. So there's been a tragic incident at a reservoir near New Orleans. 2 honeymooning water skiers have died. A federal employee was sitting atop a tower that looked down on the reservoir. With full knowledge that there were skiers nearby, he opened the huge floodgates to let out water, which was his job, by the way. There was no particular need to drain any water at that particular time. There wasn't any urgency or an emergency, but he did it. The force of the current he created sucked the 2 married couples through the gates, and one member of each couple, one husband and one wife, died. The surviving spouses have sued the federal government in court, and after a trial, the lowest level, the district judge found that the government employee's actions went beyond gross negligence, which is the standard in a torts case, and constituted a classic example of death and injuries resulting from conscious governmental indifference to public safety. So in other words, the employee should have known better not to flood this reservoir at this time, knowing that there were people in it. Here's a nice visual you can get. Guys water skiing in the reservoir. You see the dam facility is going to open up the waters, right? It's not like a ton of water comes gushing out, but it's enough water where it then creates a force that then pulls the skiers against their will, right? They're going a different direction than they intended, and then that's going to result in their death. The problem here in this case, right, you might think it's a simple issue. You say morally, of course, right, the person who's responsible should be judged. Well, that's not how law works, right? It's not just based on how you feel or based on your moral opinions. By the way, on that last case, you'll get a 50-50 split in most cases. Some people say, well, right, it's like buyer beware, caveat emptor, right? Why are you water skiing in a reservoir, right? Not the smartest place to water ski, right? So it's kind of like train surfing, right? Is the train conductor responsible if they stop the train suddenly because of something on the tracks, because some kid is up on the roof, right? Should they have known? Did they know, right? Are they responsible for that? Some people would say no, right? The kid shouldn't be on the roof. These people shouldn't be in the lake or in the reservoir. Other people would say, well, of course, if you see them, then you should try to exercise some caution and try to take care of that person. So people will disagree politically and morally. However, again, that's not how the law works. The law works, right? We have to interpret statutes. We have to interpret laws that have been passed by the government. And so we've got 2 laws that seem to create some difficulty for us. One is the 1952 Torts Claim Act, which says that tort actions against federal government are allowed, right? You can sue people in the federal government, but it excludes any actions that a government official takes in the 1928 Flood Control Act. And the Flood Control Act says that no liability of any kind so no responsibility, shall attach to or rest upon the United States or any of their employees for any damage from or by floods or flood waters at any place. So the issue, whether this is going to embrace the loss of human life, did they mean to include human life? That's a question of interpretation. There isn't one answer. They didn't write this in the law itself, and so the judge now has to interpret whether they should let the couple sue or whether they should throw the case out. So the legal rules, similar to what you did last week, here are the legal rules for this situation. The contents of the reservoir are floodwaters. It counts as a floodwater because the Supreme Court opinion has said so before. So that's legal reasoning using precedent, right? Previous cases. The statute from 1928 is a little bit outdated. In other words, the recent trend in the courts is kind of going against the idea that, in all situations that the government is not, you can't sue the government in flood cases. But again, the law hasn't changed. It's just that the judges have been interpreting it so that people can sue more often than not. Not always, but more often than not. The purpose of the statute was to prevent a rash of lawsuits against the federal government for massive flood control measures after the devastating Mississippi flood of 1927. So in other words, if you can imagine there's a reservoir in Central Park in Manhattan, there's really, really bad rains for, let's say, 3 days, a hurricane hits, like Hurricane Sandy in 2012, and there's a flood and it causes damage to apartments on the Upper East Side. So let's say then New York City Council and the state legislature say, we're going to pass a law and we're going to create a basin that's supposed to catch all the water before it gets to the apartments. They'll also pass a law saying you can't sue us based on this effort we're making, right? Because there's no guarantees. We can't promise that the basin will hold all the water, so therefore you can't sue. So let's say 40 years go by and nothing has happened, and then there's a big flood, but it's not a hurricane flood. It's just kind of like really heavy rains one day, and the basin overflows, and then that causes damage to some restaurant owner, and now they want to sue. Well, that's not something they thought about at the time, so how does a judge interpret that act? It's a similar situation. So the rule is that this idea that you can't sue government officials should be narrowly construed, so not liberally applied. It shouldn't apply to everybody all the time. It should be a case-by-case basis that judges decide kind of based on the situation and the urgency. The original drafters, that's code language for originalism, of the immunity law, as far as known, could not have foreseen the reservoir would be used recreationally. So when they passed the law in 1928, they weren't thinking about water skiers in a reservoir. Now, on the other hand, the language of the law is very broad, and it says no liability of any kind, of any damage at any place. So this kind of argues against that previous statement, that if the original drafters didn't intend for human life or for water skiers to be included, then why did they draft the law so broadly here? Why does it say no liability of any kind at any place of any damage? So here we are, we're at a court of appeals, right? They've appealed the district court, and now you're one of the three judges, right? So one judge holds that individuals can sue because the original framers of the law did not explicitly forbid the loss of human life as a damage. In other words, they didn't explicitly say it, and so therefore that means people can do it, right? If the Congress didn't want them to, they would have said no. On the other hand, another judge says, no, individuals can't sue because the language of the law states any loss, not just property loss, and thus the government is immune. So the first one is an originalist, the second one is a textualist, and they're voting against each other. So you're the third vote. So how would you rule? What would your basis be? Are you an originalist? Are you a textualist? Are you something else? How are you making your decision? What interpretation method would you learn from that you learned from class? Maybe go back to the sovereignty cases. How are you thinking about making your interpretation? And then what are the far-reaching consequences of your decision, especially as it affects people of color, as it affects tourists, as it affects poor people, as it affects women, right? Think about it. How is it going to affect different groups differently? So I thought it was interesting, right? In one of the comments, judges' power is dangerous, right? Although you learned previously in previous classes that, hey, that's part of the separation of powers. It's checks and balances. It's super important, right? So now you're learning that maybe it's not so great. Maybe the idea that unelected people making these decisions is a difficulty. That is also the controversy going on in Israel at this time. It's also been pretty common in the European Union as well, that people have pushed back against the idea that judges should make difference. On the other hand, the other side's saying, well, but why should Congress just get to do whatever they want, right? Why should politicians get to make all the rules and there's no check at all? So, it's not clear, right? There's not one answer here. So this power, as you may or may not know, comes from Article 3 of the United States Constitution. And here's a judge explaining this in a case in 1961, right? This idea that judges can make declarations about what is law or what isn't, or what's constitutional and what not, is an old one, right? It goes back all the way to Marbury versus Madison, where Justice Marshall said, we must never forget this is a constitution we're expounding, meaning this is the thing we're trying to figure out. It's not clear, right? A constitution is only a set of principles. It's not really like a roadmap. So any question that comes before the court has to be appropriate for the judges to make a decision on. It can't be hypothetical. It can't be abstract. It's not an academic question. It's not something that's already been decided. It has to touch on the legal relations of the parties having adverse legal interests. In other words, each side is pointing to different laws or different constitutional provisions or different interpretations and saying we have rights that are being infringed, right? So it's not clear. There's not one answer. There's at least two sets of issues, and in some cases you can see 5 or 6, as in the Dubs case. And those issues must be real. They can't be fake or made up, and they have to be substantial. They can't just be a minor thing. Although I think in the student debt forgiveness, the quote-unquote real interests of the state of Missouri were not substantial. However, the court decided that they were. And admit of specific relief through a decree of conclusive character, meaning there has to be some remedy that the court can give you. So you can't come in the court and say, I have a real and substantial interest, but I'm not really sure what the court should do. You have to say, this is what we want you to do. And you'll see, people have different opinions on how this kind of works itself out, and that's also true of society. So by this point now, you really should fully understand 3 main concepts of this course. They're super important for you to be able to move on to future courses in criminal justice and law. The first is the malleability or the flexibility of the law, right? It's not one thing. It's not one rule. It's not just a set of procedures. It's a way, it's an integrative function, meaning it's a way for things to connect with other concepts, such as ones we've talked about in this class. Jurisdiction, precedent, stare decisis, a preference for predictability, stability in the principle of rule of law. Also, you've talked about sovereignty. You've talked about now checks and balances and separation of powers, and so it's how this is like the glue that holds all those principles together. But it also includes the roles of the lawyer and the judges in order to shape their arguments within this place we call courts, or within the law, right? And so they're restricted by certain rules, and they don't use things like motivated reasoning that you see on the talking heads on social media. Or your cousin's opinion about this, right? They don't use those formations. They use only previous cases, and so you've got this kind of restriction, but you've also got this flexibility of this thing. I like to think about it as like clay that you're sculpting, right? One person might make a statue that looks like a person. Another person might make a statue that you're not sure what it looks like, right? And so that's what we mean by malleable. It's shapeable. Now, we also then see why this is the case is because there's not one interpretation of legality. There's multiple, or many, meaning poly, right? So there's many voices of the law. And so an empirical finding meaning something we see in real life, not a thing that we deduce or we just make up, but what we collect from normal everyday people and lawyers and judges is that they hold many ideas about legality, often at the same time. You might go through your answers and see how many different times you agree or disagree with yourself in your discussion board posts. And these include law as a game. This is with the law. I feel like I'm running with the law and I'm using it as a tool. As an ideal, I feel like I'm before the law. It's very sacred and it's very important to me. Or it's a tool that can be abused and resisted. I feel like I'm up against the law. People are using it to hurt me, right? And so there's 3 different ways that have been identified over time. Students have also raised a 4th one, above the law, but I think that needs a little bit more clarity. But I do think this idea that people are judged at different levels, right? So the more wealth and power you have different access and uses of the law. Finally, there's legal reasoning, which is really what this whole presentation is about. It's a method of finding reasons for a proposition, for some statement that you're making, using previous uses of legal rules, or sometimes larger constitutional principles like sovereignty, that tend to support a conclusion and it's consistent with those cases. Or you're using it to argue against it, as you'll see in what are called dissents, and those deviate from some cases because they show the principle to be inapplicable. And this is really what happens in the Dobbs case, right? They say that the previous cases, the rules that you just identified, were not usable in their opinion. So then this leads us to our final set of readings, which are asking you now to look at these contradictions very concretely and to see how the economy in particular fits into it. And so I'm looking for you to be able to, on the final exam, explain how these contradictions influence the interpretation, right? If you're leaning towards property and commerce and business and capitalism, you're going to rule against individual liberty and the social good. If you're ruling in favor of liberty and the social good, you're more likely to rule against property and business and capitalism. And so you'll see how this works out in Marbury versus Madison, which is probably the most underappreciated and misunderstood case in all of constitutional law. You get like a Wikipedia entry of judicial review and everybody pats themselves on the back as if that's really what the case is about. It's not. It's about the power of slaveholders and who they get to appoint as people who track down runaway slaves. And so it's a huge property interest case more than it is just judicial review. Ward's Cove versus Antonio shows you again how property interests are preferred by the United States Supreme Court over individual liberty labor interests. In Wickard-Filburn, you see this again, where the economy is more important than the individual rights of one farmer. In Citizens United versus the FEC, you'll see again that money and politics are more important than the rights of the people to get good information and to find out who's actually paying for the political campaigns and who is donating. We call it bribery in other countries, but in this country we call it campaign donations. Who's actually doing that? So now we don't know because of this case. And then there's Plyler versus Doe that rules for the social good of children, even if they don't have documentation status. And then EPA versus Homer City Generation shows that the Supreme Court feels that they can't really talk about climate change, and they don't want to give any additional power to the executive branch, which is really interesting if you contrast that to the Trump versus Hawaii, where they had the opposite point of view. And so you see a contradiction here again that because national security was involved in the Trump case, but here in the EPA case, it's economic interests. They rule against the federal government in favor of the private capitalist interests. So if you write a 5-page paper about that, it would help me see how you're understanding these concepts, but it would also potentially boost your grade. I'm sorry about the noise in the background. Hopefully I'll just get through this. The structural contradictions are present in a field of unequal social relations, and you've attempted, or you've reviewed, I hope you haven't just attempted, you've reviewed these cases that show you what these constitutional interpretations do, what effects they have, and the attempts to resolve social problems. What you'd see here is that there are certain contradictions that develop over time and are repeated throughout different cases, and this is a contradiction between fundamental rights of the individual, but you also see those who are excluded, as in the case of Africans, women, people who want to get abortions, etc. This next set really look at the criminal justice system. You saw those contradictions that arise between trying to balance order and individual rights there. And so what you should see is there's a gap between the ideals of things like the Bill of Rights or the Declaration of Independence and the practice that actually happens in policing, corrections, and the courts. And so these should raise really important questions about whether we really live in a democracy, how the state actually functions, what a modern economy looks like, and whether you actually have liberty or do you have something sometimes the judges call ordered liberty, which doesn't sound much like liberty at all. And so you want to think about the choices that judges have. Remember that it's a closed legal system, right? So they can't just do whatever they want. They're influenced by their backgrounds, their culture, their experience, education, training. So if it's not equal or if it's not diverse or it's not well represented, then don't expect their decisions to be either. And things change with different judges at different historical moments. I think one student was a little bit optimistic that maybe younger judges of the future will be more open-minded and more prone to social good. However, not if they have the same backgrounds, culture, experience, education, training as the older judges. Then there wouldn't be any change at all. And remember, that's the only world they know, right? So they don't know what it's like to be like poor and working and things like that. So you should be able to figure this out from now on when you look at the language of the cases as well as how they frame the issues. And just remember, they're constrained by previous cases, although they can overturn precedents, as you see in Dobbs' case. But you still have to do that by using previous cases. So for the Dobbs case, it's interesting to look at the majority versus the Roberts opinion, where Roberts says that the Constitution still does give women the right to an abortion, whereas the majority says no, that's not the case. So you'll see even within the right side of the court, the originalists, they disagree with each other. So I want to see on the final long exam answer, if you want full credit, that you're going to do an intersectional analysis, race, gender, and class, and use standpoint theory. So contrast yourself to that. I think one student did a pretty good job of this. I think maybe be a little bit more confident in your answer and say, I don't have an opinion on this because I'm a man. That really doesn't make any sense, right? Because men are the people who get women pregnant in the first place on abortion cases. So it's okay to say, because I'm a man, I see this differently, and then explain it. But I don't think it's to say I can't have an opinion because I'm a man, because that really reduces the concept into a way that doesn't make any sense. So what we do want to see is, how are our identities constituted by the legal order, right? So what is a man? What is a woman? What is a fetus? What is a child? Right? These things are not things that are decided by science. They're decided by the courts, right? The courts make these decisions. We want to contrast that to the conceptions that we have in our everyday social settings. They're often very different, and that's what helps us understand the polyvocality of legality. I want to see this in your answers and how this affects the consequences of democratic engagement. And then you want to think about how people might start to engender agency. How might they resist and organize and work against these trends? So I want to see all those things in your final answer. So the exam itself is going to have 4 parts. There's 30 multiple choice questions or points available, and those will pull from many of the questions that you already took in the quizzes that I've given answers to on these presentations. But it's an open book, so go ahead and use the book, and especially the definitions pages. For the final answer, I've given you ideas on how to do that. That's up to 10 points. And you're going to want to make sure that you follow these instructions well, and that you want to read the Dobbs opinion and compare that to the Roe v. Wade opinion and those legal rules from that section. I need to see evidence of civic engagement for you to be able to pass this class. It's a civic engagement graduation requirement class, and so you need to be able to clearly refer to activities or readings that you thought really help you deepen your civic knowledge, and then you want to be specific about that and look back at the definition and learning outcomes I give you in that document. It's a Google form, and so you'll have time, but do try to finish it in one sitting. And then finally, I'm going to give you extra points. I'll increase your grade if I see evidence of legal reasoning, especially as you relate it to standpoint theory, and you definitely want to talk about readings and cases in order to get full credit. So this is again why ChatGPT and just copying and pasting from the internet you don't do well in my class when you do those things, because you're going to have to get the answers from the book and to show that you actually understand what you've read, right? It's a big issue in legal reasoning cases. You have to be able to show that you understand, not just copy and paste something. So I really want to see you thinking through these answers, and again, that will boost your grade. Many of you are doing a great job of that in the discussion boards, so just keep up the good work. And really just try to think about what I've said today. Go back and look at the discussion boards and look at your colleagues. There's lots and lots of great answers in there that you can learn from, and just continue to engage all the way through to the end here, and I think everybody will be in a good place.